Thank you, Dr. Raj and Dr. Sharda Jain and all of you for giving me this opportunity to talk on this new set of regulations. And I'll try to decode this code of ethics as best as I can. All reforms come with some disruption. Some persons will like it, some won't like it. Same is true with this regulation, which has come into operation since August 2, 2023, with the Gazette notification, now put on hold for review of some areas. We should look at this regulation as a healthcare reform. So let's examine this in an objective manner without being swayed by emotions. On a lighter note, be prepared to be addressed as RMP, as NMC has addressed us as RMPs. This term used to be reserved for quacks earlier. I wish NMC had expanded it as registered medical professional rather than as registered medical practitioner. There is also an implied equivalence with our Ayurveda and homeopathy counterparts. The ambiguities in the regulations could be interpreted to our advantage till the clarifications are provided by NMC. This regulation has 5 chapters and 11 guidelines. I don't intend to go into all of them because that would be very lengthy and boring. I will just try to club them into 4 heads. First one is the basic aspects, which includes most of the issues which were already existing and which have been fine-tuned by NMC in this regulation. And the other 3, the generic medicine, the CPD, and the telemedicine, these are the relatively new areas, and we need to go deep into what the NMC thinks about it. I'll first talk about the basic aspects and then take on these 3 aspects. Registration and qualifications. Fresh online registration with NMC has to be done, as well as with the SMC of the states where you want to practice. This has to be renewed every 5 years after submitting documentation of CPD hours. You can display only your degrees and diplomas which are recognized by the NMC. They've given this link, and in this link, all the degrees and diplomas which are recognized by NMC are given. Against your name, you cannot add any other qualification or fellowship or whatever which is not included in this list. Projection of qualifications and expertise should be commensurate with the NMC recognized qualifications only. For example, MS in OBG claiming to be infertility expert, or a general surgeon claiming to be a laparoscopic surgeon without NMC recognized qualification or training in these fields are violations. Writing memberships or gold medalists, etc., are prohibited. Cross-pathy is prohibited. You cannot associate with or employ any unqualified person for professional treatment or care. Employment of RMOs with qualifications like BAMS, DHMS, etc. is strictly prohibited. Such persons may still be employed as clinical clerks or assistants or helpers or managers without any liberty of prescribing any medicine on their own or projecting themselves or working as RMOs. Testimonials, fee, and selection of cases. Issuing certificates of proficiency in allopathy to any unqualified, unskilled, or non-medical person is prohibited. Certificates may be issued to medical professionals, students, and trainees of upskilling, etc., but the certificate must contain the details regarding experience, skills, and competency obtained, duration of the training, and kind of work done during training. Consultation fee has to be displayed properly. Estimate of cost of treatment, surgery, and care has to be provided to enable the patient to take an informed decision. You can refuse to treat or continue to treat a patient if the fee is not paid or he is getting abusive or aggressive. However, even when you refuse to treat, the patient should not be abandoned. This refusal to treat does not apply to RMPs in government service or in emergencies. The option of selecting whom to treat was available earlier too, with the same exceptions, but now the NMC has added a rider stating that such a patient should not be abandoned without specifying as to what it means. So it is suggested that we should document referral of such a patient to another hospital, preferably a government hospital, instead of mere refusal. Of course, we should remain polite and tactful in spite of provocations while refusing a patient. Soliciting patients. RMP shall not solicit patients directly or indirectly or as part of any organization or institution. It is prohibited to boast of good results of treatment, etc., or endorse any medicine, device, or any other product, or endorse any person or any company by doctors, hospitals, or associations in any manner with compensation or otherwise. EMRB stands for Ethics and Membership and Medical Registration Board. EMRB has no jurisdiction on organizations and institutions, but has full jurisdiction on RMPs. It will therefore identify participation of RMPs in such campaigns. However, EMRB can refer the matter to its other boards for action against educational medical institutions registered under them. Fee splitting and commissions. RMP shall not directly or indirectly participate in any act of splitting of any fee for diagnostic, scanning, medical, surgical, or any other treatment. These provisions shall apply with equal force to the referring, recommending, or procuring by RMP of any patient, specimen, or material for diagnostic purposes or other studies. However, nothing in this section shall prohibit payment of salaries by a qualified RMP to another duly qualified person rendering medical care under his or her supervision. RMP shall not use online forums or agents for procuring patients. Platforms like Librate may be used only for telemedicine with strict protocols. Receiving gratifications. RMPs and their families must not receive any gifts, travel facilities, hospitality, cash or monetary grants, consultancy fee or honorariums, or access to entertainment or recreation from pharmaceutical companies or their representatives, commercial healthcare establishments, medical device companies, or corporate hospitals under any pretext. However, this does not include salaries and benefits that RMPs may receive as employees of these organizations. Also, RMPs should not be involved in any third-party educational activity like CPD, seminar, workshop, symposia, conference, etc., which involves direct or indirect sponsorships from pharmaceutical companies or the allied health sector. RMP should be aware of the conflict of interest situations that may arise. Advertisements. RMP is permitted to make a formal announcement in any media within 3 months regarding the following: on starting practice, on change of type of practice, on changing address, on temporary absence from duty, on resumption of practice, on succeeding to another practice, or public declaration of charges. RMP or any other person, including corporate hospitals, running a maternity home, nursing home, private hospital, rehabilitation center, any type of medical training institution, may place announcements in the print, electronic, or social media, but these should not contain anything more than the name of the institution, type of patients treated, kind of doctors and staff training and other facilities offered, and the fee. RMP is allowed to do public education through media without soliciting patients for himself or the institution. Sale of drugs by RMPs. RMP shall not run an open shop except to sell medicines prescribed by himself for his own patients. Medicines prescribed by other RMPs cannot be sold from his shop. Drugs prescribed by RMP or bought from the pharmacy for a patient should explicitly state the generic name of the drug. Prescription of generic medicine is recommendatory, not mandatory, as they've used the word should and not must. Medical records. Self-employed RMP shall maintain inpatient records for 3 years in a standard pro forma laid down by the NMC. It is silent about RMPs employed in the hospitals. If any request is made for medical records to RMP responsible for patient records in a hospital or healthcare institution, either by the patient, the same may be duly acknowledged, and documents shall be supplied within 5 working days. Efforts shall be made to computerize patients' medical records for quick retrieval and security. Within 3 years from the date of publication of these regulations, the RMP shall ensure fully digitized records. For certificates and other documents signed by RMPs for administrative legal purposes, they should not be untrue, misleading, or improper. A self-employed RMP shall maintain a register giving full details of such certificates issued by him. Though not mentioned, even when employed in a hospital, it is prudent for you to keep a record of the certificates that you issue. Retaining OPD records is not mentioned in the NMC regulation, but it is in your own interest to retain them also for 3 years. In litigation, one is handicapped if the complainant has all the OPD slips, but you don't have a copy of the same. It is prudent for doctors to switch over to electronic medical records, which has a lot of advantages. For the existing manual records also, it is useful to digitize them by scanning them and category-wise uploading them as PDF files. Now, consent. Before any clinical procedure, diagnostic or therapeutic, signed, written, informed consent of the patient is necessary. In case the patient is unable to give consent, the consent of next of kin must be taken. The name of the operating surgeon and the correct name of the procedure must be mentioned. In an operation that may result in sterility, the consent of both husband and wife is required. No act of in vitro fertilization or artificial insemination shall be undertaken without the informed written consent of the female patient, her spouse, as well as the donor. For an emergency, try to obtain consent, but in life-saving procedures, you must act in the best interest of the patient, even without consent. The details must be documented and preferably endorsed by another surgeon. RMP shall not publish photographs or case reports of patients without their consent in any publication in any manner by which their identity could be revealed. Clinical drug trials or other research involving patients or volunteers must comply with ICMR guidelines and the new drugs and clinical trials rules of 2018. Consent can be either implied or explicit, verbal or written. Implied consent is applicable for clinical examination, including pelvic and PR examinations. For sensitive physical examinations like PV, PS, PR, or breast examination, an express verbal consent must be taken, even though NMC is okay with implied consent. This is medically, legally, and morally necessary. Explicit written consent is required for all procedures, treatments, surgery, and interventions that have commonly known risks to the patients. Presence of a female attendant is essential when male physicians examine the female patients. Informed consent can be taken only from adult and mentally sound patients. It must be free and voluntary and in a language understood by the patients. In major surgeries, it is in the interest of the patient to execute an advance directive nominating a legal representative who can give consent on their behalf if required for further procedures during surgery when the patient is incapacitated. This proxy consent or surrogate consent or power of attorney or advance directive should be taken along with the admission consent. This will help in case extension or modification of procedure is required during surgery. All consents for procedures with a potential risk should be documented. Consent must be procedure specific, mentioning complete name of the procedure correctly. Pre-printed procedure-specific informed consent can be made available after prior approval from the SMC or EMRB. However, the responsibility of administering the informed consent is on the primary physician. The pre-printed consent forms, which were objected to in one of the court decisions, are acceptable to NMC. However, it prefers prior approval from SMC or EMRB for it. It is therefore advisable for the professional bodies to prepare procedure-specific informed consents for main operations performed by its members and get the approval of SMC or EMRB. That can then be used by its members without question of legal discrepancy. A patient undergoing 2 separate elective procedures needs to give consent for each operation. Similarly, fresh consent must be taken for every new procedure planned for the patient. Consent must be taken separately for surgery and anesthesia. Leave no blank spaces. It should be signed at the correct places. It should also be signed by the doctor performing the procedure. It should be witnessed by preferably 2 persons. In case of an interpreter helping, he should also sign as a witness. Signatures of all should have their name, role, phone number, and date mentioned. There are some special situations where consent becomes different. In emergencies, consent for treatment should be taken from patients wherever possible and from legal representatives whenever available if the patient is unable to give consent. In life-threatening situations, we have the therapeutic privilege to go ahead without any consent. However, in such a situation, do only the life-saving procedure and nothing more. And it is better to make a detailed note in the file and get the signatures of another doctor knowledgeable about the case. In the case of minors, the parents or guardians must provide the consent, although assent may also be taken from the children above 8 years of age. In case of vulnerable groups, it is particularly important to have a witness during the informed consent procedure and take the signatures of that witness as well. In clinical research, follow the protocols given by CDSCO and ICMR. Medical students and consent. In examining patients by medical students for teaching, learning purposes, students must be educated about the process and importance of consent. Medical students should take verbal permission from their patients before examining them, and the patient's decision must be respected, including refusal to be examined by the medical student. Patients do not need to give any reason for this refusal, and clinical care of the patient must not be adversely affected in such cases. Refusal of consent. Patients have the right to refuse treatment, and this right should be respected. RMP should communicate all possible risks of the refusal and document the patient's refusal to be treated and the reasons given for the same. Personal data that can reveal the identity of the patient should not be disclosed under any circumstances, except to the members involved in treatment and care of the patient. However, for the use of patient's data in academic teaching or clinical case discussions, patient's consent is required. Under no circumstances will the patient's data be posted on social media. Now, the crucial question is how much of risk to be disclosed. The NMC regulations have mentioned, they've cited 2 court judgments to help you assess the amount of risk to be disclosed. One is Montgomery versus Lanarkshire Health Board. The other one is Samira kOHLI versus Dr. Prabha Manchanda. I would suggest that at least the Samira kOHLI versus Prabha Manchanda judgment should be read by all of you, maybe multiple times, to understand what the courts expect you from about the consent. Now, briefly, this disclosure of risk follows 2 different doctrines or principles. One of them is prudent patient principle. In this, it means you must disclose the risks which any average prudent patient would want you to tell. And as we can understand that any patient would like to know all the risks that may happen or may not happen, which are associated with the particular surgery, even the remote risks he would want to know. This type of consent, which is followed by the American courts, it tends to be a very large document. This is more or less like a booklet. The other principle is what is known as prudent doctor principle, which is followed in the UK and largely in our courts. This means we should disclose the risks which any average prudent doctor would disclose to his patient for him to make an informed decision. So he would generally prefer not to disclose the remote risks or which are very unlikely in a given situation. So in our courts, by and large, this prudent doctor principle is followed, but there is a gentle trend heading towards the prudent, the American concept also in the Indian courts. Now, the social media conduct. The broader principles of medical ethics apply to social media also. Secondly, distinguish between telemedicine consultation and social media chats. Then all written and visual communication should be truthful, respectful, and professional. Social media can be a great resource for doctors. We cannot think of active life without the use of social media in today's context. Its use is going to grow further with artificial intelligence coming in, but it is not without its risks. Privacy laws and data protection laws must be kept in mind during your social media professional interactions. NMC permits educational activity on social media, but prohibits direct or indirect marketing by doctors. NMC also wants your educational activity to be limited only to your field of expertise. Soliciting of patients on social media is strictly prohibited. These are some of the other rules given on social media. RMPs can provide information and announcement on social media, but it should be factual, verifiable, and not misleading or deceptive. General guidance is okay, but avoid discussing or prescribing treatment. Guide him for telemedicine or in-person consultation if required. Never post patients' photographs or reports or images on social media. Once an image is posted in social media, it becomes data that is owned by the social media company and is accessible to the general public. RMPs should be guided by general principles of medical ethics on professional behavior. Do not indulge in the practice of purchasing likes, followers, or paying money for better visibility or better ratings on social media. Do not seek or share testimonials, recommendations, endorsements, or reviews from patients on social media. Refrain from sharing images of cured patients or videos or images of impressive results under any circumstances. Follow similar guidelines on your website or app if you have. A word about OPD prescriptions. All patients, even free and complimentary patients, should be registered. Always make a working diagnosis with the help of good history and clinical examination and document it. Write complete prescription legibly with medicinal and non-medicinal instructions. Mention plan of treatment. In follow-up visits, mention the progress and further plan. Also mention if there are non-compliances with your previous instructions. Mention precautions at home and your contact details. And you must retain a copy. Something about medical certificates. The medical certificate is a legal document and should be given carefully, based only on the medical condition of the patient. Any false certificates may expose a doctor to punitive actions by the NMC or by the civil or criminal courts. The guidelines apply to government doctors as well as private doctors. The certificate should be legible and based on the format given by the SMC or NMC. No certificate should be given without examining the patient physically. The registration of the patient's visit to the clinic should be ensured, and the patient signatures should be taken in your presence. If it is a minor, in case of, say, school children, the signature should be that of the parent or guardian, along with the signature of the child. All this will indicate that the certificate has been issued after actual physical examination. All medical certificates should be serial numbered. A copy of the certificate must be retained. The certificate should have registration number of the physician mentioned. The certificate should be prospective. That is, a doctor should state the probable period of absence from the date of issuance of the certificate. A certificate should not be retrospective normally. Sometimes a short retrospective certificate may be issued, but in that case, a retrospective nature of the certificate and its reasons must be stated clearly. For example, a person could not attend office on account of high-grade fever, but intimated his office prudently. He depended on home treatment in the hope that it will work. However, the fever appeared again the next day, and so he attends a medical clinic the next day. If the doctor is convinced, he may give the certificate with effect from the day before, making a mention of the retrospective nature of the certificate. The date of issue of the certificate, however, should not be backdated. The certificate should be addressed to the intended person, the employer or the school principal, etc. In other words, generic certificates with the heading "to whom it may concern" should be avoided. A doctor may write statements like suitable for light work, unfit for driving vehicle, unfit for weight bearing, or unfit for air travel, and so on, as the case may be, if it is within the professional expertise of that doctor. For example, a gynecologist may not certify whether a patient with leg fracture is fit to join duties. Similarly, a physician cannot certify bed rest after radiotherapy, or a surgeon is not competent to write fitness certificate for a case of acute myocardial infarction. However, there can be bona fide exceptions once in a while. Normally, a certificate should be issued for a maximum of 15 days. If longer rest period is considered necessary, further extension of leave certificate should be issued after that period of time. If a doctor thinks that a very long period of absence is desirable, then it is better to refer the case to district civil surgeon or to the medical board of the hospital for approval. The medical leave certificate and the medical fitness certificate should be given on separate dates as per actuals and not combined in one. In the template given by the NMC, where both are mentioned in the same certificate for convenience, the doctor must strike off whichever statement is not applicable in a given case. Complaint of professional misconduct. The aggrieved person files the complaint to the SMC online. The NMC or EMRB or SMC can initiate a suo motu case against any RMP taking cognizance of gross misconduct. Notice will be sent to the doctor for his reply and documents. SMC will inquire through its committee with relevant experts. No lawyers are allowed to represent any party. After decision, the SMC may dismiss the complaint or warn or counsel the doctor or restrain or suspend his license or award monetary penalty according to different levels of professional misconduct. Aggrieved party can file an appeal before the AMRB and then to the NMC. Now, let's come to generic medicines. There are basically two types of medicines: patented medicines and non-patented medicines. The patented medicines are the discovery medicines or the actual branded medicines. Non-patented medicines are actually speaking, broadly speaking, the generic medicines, because these are made after the expiry of the patent. So these become the generic medicines. They may be of two types: proprietary generic medicines, also called the branded generic medicines, or non-proprietary generic medicines, or the generic medicines. In India, there are very few patented medicines prescribed. The maximum prescriptions are from the category of non-patented medicines. The branded medicines that we are generally prescribing are from category 2A. The NMC guidelines want us to prescribe 2B, 2A, or one category medicines in that order of preference. Secondly, It is recommendatory rather than mandatory rule. A greater reform is actually required in drug licensing practices, which ought to be clear, objective, non-corrupt, and scientific. There is also a great need to tackle the menace of fake medicines with drug labels similar to brand names. I'll give you an example. Paracetamol is a common medicine to treat fever and pain. Paracetamol was first made in 1878. It was patented later. The chemical name of this compound is para-acetyl-aminophenol. Paracetamol or acetaminophen are the globally accepted given names or the common names for this medicine. It was patented by a company and marketed as Panadol. This was the original brand name called the patented branded drug or the branded drug or discovery drug. When the patent expired, several companies began producing this drug. All these drugs come under the category of generic drugs. Some of these companies have been marketing this under their brand names like Crocin, Calpol, Dolo, and so on. These are the proprietary generic drugs or branded generic drugs. Some companies for mass production have preferred to market their product as paracetamol without giving their own brand name. These are non-proprietary generic drugs or generic drugs. Since in India there are very few discovery drugs, most of the prescriptions even today are generic drugs. The choice is between the branded generic drugs and the generic drugs. Now, what is the controversy? The discovery drugs are prepared after rigorous R&D and marketed after the drug trials in 4 phases to ensure its safety and effectiveness and to establish the proper dose. Separate trials are required to assess in special category of patients like children, pregnant and lactating mothers, and geriatric groups. After the company gets the license to market the drug, it can apply for a patent, which is a stringent, long-drawn process. Once a patent is granted, the company gets a monopoly and tries to recover the expenses incurred in the R&D and the drug trials and also obtain profits. The patent is generally for 20 years. When the patent expires, the monopoly is gone and other companies have the liberty to manufacture that drug. However, they have to satisfy the regulators about the chemical equivalence and the bioequivalence of the drug with the discovery drug. These processes are much less expensive as compared to the regular drug trials. In India, the regulators permit the manufacturers to do these in their own labs, these chemical equivalence and bioequivalence in their own labs. Secondly, they are okay with chemical equivalence study without having to do bioequivalence study. And thirdly, for some category of drugs, even chemical equivalence study is exempt. There lies the problem. The chemical equivalence rating is okay if it is more than 90%, it's substandard if it is 70 to 90%, and considered fake if it is less than 70%. Now, good companies, especially multinational companies, are expected to ensure good quality of proprietary generic medicines for their own sake, for their own reputation, and hence the doctors have a better confidence in them. Similar degree of confidence cannot come with the non-proprietary generic drugs under the prevailing Indian conditions. Now let's come to continuous professional development, or CPD in short. NMC has replaced CME with CPD by widening its scope. CPD includes overall professional development, that is conventional study plus soft skills plus cross-discipline skills. Secondly, it has been made learner-centric rather than speaker-centric. NMC has defined the process of delivery of CPD programs, the assignment of CPD points, the linkage of CPD points with renewal of licenses by the EMRB or the SMC, and the penalties involved in case of non-compliance. CPD and recertification should not be viewed as a threat, but as overall upskilling responsibility to provide patient care and services of the highest order. Now, who can impart CPD? Registered medical professional bodies and associations, medical colleges recognized by the NMC, hospitals approved by DNB program, approved for DNB program, research institutes involved in healthcare research, and other recognized institutions involved in healthcare training and education. Interested institutions must register with EMRB or the SMC through a defined process. These institutions will need to develop the CPD program, identify the speakers, and obtain approval from SMC for conducting the program, to disseminate information, ensure adequate enrollment, besides conducting the program itself, and then obtaining feedback and submitting the report. Content of the program should be based on need assessment with clear objectives and learning outcomes, with 3 categories of CPD. So these CPD category, CPD complexion has been divided into 3 categories. Category 1 is 70% of the program should be related to knowledge updates and skill development in the specified subject area of the patient care. This is what should be the 70% of the program. Now, 30% of the program should be devoted to cross-disciplinary areas like bioethics, professionalism, communication, public health, policy, evaluating evidence and biostatistics, and so on. Apart from this, there is an optional category, self-directed online CPD or scholarly work. After approval of the CPD program by EMRB or SMC, it is sent to CPD committee for EMRB for registration and grading of the CPD program. The CPD programs may be delivered offline or online depending upon the nature of the CPD. However, online delivery should not be more than 50%. Ensure active participation and not merely attendance of an event. If the CPD is being conducted online, organizers must indicate how they intend to ensure active participation during the entire program. Active participation may be documented through exercise during CPD or online questionnaires like Google Forms. Participants are required to be present for the whole session and should not be given certificates of CPD points if they have not attended the whole program. Every CPD program should have an internal evaluation process which can broadly assess key participant learnings. CPD programs will be reviewed by EMRB Accreditation Committee for grading and evaluating speakers, quality of content, sessions, audience participation, and so on. CPD credits. Every RMP should identify his own professional needs and register accordingly to earn credit points. Maintain a record of your credit point, CPD points, which will be updated onto the EMRB portal. There are penalties for non-compliance. RMPs have to attend both Category 1 and Category 2 CPDs in 70 to 30 proportion. Category 3, or the self-directed online program category, may be opted, but it should not be more than 50% of the whole, barring special situations. EMRB and SMC will help the RMPs in the logistics of the program. A minimum of mandatory for every 5 years for license renewal. Doctors are encouraged to obtain 6 CPD points every year. That means 6 into 5, 30 CPD points for 5 years. But in no year, it should be less than 3 points. While faculty in medical colleges and DNB hospitals are routinely training medical students, this effort will not give CPD credit points. Earlier, they were awarded 2 points every 6 months. Now, these faculty members will have to achieve the mandated CPD credit hours as for other RMPs. Different forms and templates for certificates, etc., all annexed in the NMC regulations. Now, to explain the Category 1 and 2 of CPD, 70% of credit hours should be obtained from, these are all group programs. They should be obtained from conferences, symposia, seminar, and workshops, online synchronous or blended learning activities. You may be an invited speaker, national and international conference, or invited speaker for state level conference, or you made an oral presentation or a poster presentation. There are objective points given for all these activities. 30% of the credit hours should be obtained from group activity through simulation or exercises or demonstrations on research and biostatistics, epidemiology, NMC code of ethics, hospital management, telehealth and telemedicine, communication skills, general practice, a family doctor, and quality improvements and clinical audits. The third category is self-directed learning, which is optional. But if you go in for category 3, this should not constitute more than 50% of the total credits. This includes completing, these are individual programs. This includes completing self-learning modules on webcast or podcasts, attending online webinar, editor of a journal of recognized association, society, or organization. You may be an author, or you may be written a chapter, original article in journals recommended by NMC, systematic review, meta-analysis, original articles in PubMed indexed, and review or letter to editor or commentary, and so on. Some exceptions are given for 100% online credit points. As I said earlier, that online program should not be more than 50%, but in certain situations, 100% online is allowed if approved by the accreditation committee for certain special circumstances, like doctors residing out of the country, or females on maternity or childcare leave, or remote settings. Scoring will be for articles excluding abstracts. Now about telemedicine. Telehealth and telemedicine are two different terms. Telehealth is a broad term for use of technology in all health-related services. Telemedicine is used for healthcare services delivered by RMPs through technology. Telemedicine includes video, audio, and text mode of communication, which is done through mobile phones or computers, chat platforms like WhatsApp, Facebook, etc., or internet-based digital platforms like Skype, email, Zoom, etc. Irrespective of the tool of communication used, the core principles of telemedicine practice remain the same. Telemedicine offers an alternative to conventional consultation, but it cannot replace physical examination that may require palpation, percussion, or auscultation. Moreover, verbal and non-verbal communication in the interactions cannot be as good as in the conventional consultation. Newer technologies, however, may provide solutions to overcome this drawback. Telemedicine applications can be classified into 4 basic types according to mode of communication, according to timing of information transmitted, according to the purpose of the consultation, and according to the individuals between whom the interaction occurs. According to the mode of communication, it may be video, audio, or text-based communication. According to timing of information transmitted, it may be real-time, which is by video, audio, or text, and the interaction happens there and then, or it may be asynchronous through email or WhatsApp communications. According to the purpose of consultation, it may be for non-emergency consultation or emergency consultation. The non-emergency consultation may be a first consult or a follow-up consult. For emergency consultation, in some circumstances, telemedicine can be helpful when in-person care is not available. In such emergency situations, telemedicine consultation should be limited to guidance on first aid, life-saving measures, counseling, and advice on referral. In all cases of emergency, the patient should be advised to seek an appointment for in-person care with an RMP at the earliest possible. Then according to the individuals involved, it may be patient to RMP, caregiver to RMP, RMP to another RMP, or healthcare worker to RMP. In subcategory 3 and 4, the healthcare worker or the calling RMP can facilitate a consultation by taking history, examining the patient, and conveying the findings to the consultant RMP. They can also explain, reinforce the advice given by the consultant RMP to the patient. Now, this table is given in the regulations, which gives the strengths and limitations of the various modes of communication, about the video, audio, and the text-based communication, and the asynchronous communication. You can go through this in the regulations. The NMC regulations have given 7 key elements of telemedicine consultations. I'll touch upon them one by one. The first is context. Telemedicine should be appropriate and sufficient. Use your professional judgment to see if telemedicine would be appropriate in a given situation. Consider the appropriate mode of communication based on its strengths and limitations in a given situation. The complexity of the patient's health condition may require a different approach in different cases. The complexity of patient's location and connectivity may alter the choice of mode of consultation in a given case. 2. Identification of the RMP and the patient. Telemedicine consultation should not be anonymous. The patient and the RMP should establish each other's identities. It should be carried out in a language that the patient is comfortable with. Introduce yourself to the patient with details of name, qualifications, registration number, specialty if any, and affiliation to a hospital if applicable. Verify and confirm the patient's identity, example, name, age, address, email ID, phone number, the government ID, or any other ID if needed, and document the same. In borderline situations, seek proof of the age. As in a minor, teleconsultation should proceed only if the minor is accompanied by an adult during the entire duration of the consultation. The identity of the adult should be ascertained and documented for records. Every RMP shall display his registration number on all prescriptions, their website, electronic communications, and receipts given to the patients. Mode of communication, as I said, depending upon the strengths and limitations, may be video, audio, or text. Now, patient consent in telemedicine. Assess his competence to consent, explain the benefits, explain the limitations and process of teleconsult in the language that he understands, and record his consent. Consent may be implied or implicit, depending upon who has initiated the telemedicine consultation. If the patient has initiated consultation, then the consent is implied. If the RMP or the healthcare worker or a caregiver initiates the consultation, then the explicit consent of the patient is mandatory. Explicit consent must be recorded in any form, video, audio, or text. For explicit consent in text, obtain the patient's signature or thumb impression and date of signing on the consent document, scan it and send it through email or as an image on WhatsApp, or record the same by having the patient read it aloud. If the patient is illiterate or incompetent, an independent adult to explain the details or read aloud to the patient and send the signed and scanned document as above. 5th, types of consultations. It may be a first consultation or a follow-up consultation. The first consultation is when the patient is consulting the RMP for the very first time, or the patient has consulted with the same RMP but more than 6 months earlier, or the patient has consulted with the RMP earlier but for a different health condition. The follow-up consultation happens when the patient is consulting the same RMP within 6 months of his previous consultation for the same health condition. If a patient is not able to obtain an appointment with the same RMP for a follow-up consultation and another RMP has agreed to provide the consult after going through the patient's medical conditions and records, this will also be a follow-up consultation. This will, however, not be considered a follow-up consultation if there are new symptoms that are not in the spectrum of the same health condition, or the RMP does not remember the details and context of the previous in-person consultation as well as the advice and the treatment so provided. Sixth is patient evaluation. RMP should use his professional skills to get the required patient information and previous records for exercising proper clinical judgment. If the RMP feels that the information is inadequate, he can request for additional information. If required, the session may be suspended to be resumed at a later time. If the information desired from a physical examination is critical for management of the patient, the RMP should not proceed with the teleconsultation till such time that a physical examination can be arranged, and this may be by a video consultation or examination by another RMP or healthcare worker or conventional in-person consultation. The nature and or amount of information required from the patient may vary depending upon the experience of the RMP and on the nature of the patient's ailment. RMP shall maintain all patient records meticulously and ensure their safety at least for a period of 3 years from the day of last consultation. The seventh key element is patient management. Depending upon the nature of the patient's condition, the RMP may provide health education or provide health counseling specific to the condition suffered, or prescribe medicines as per standard of care. Prescribing medication via telemedicine consultation has the same professional accountability as for in-person consultations. If a particular medical condition requires a specific protocol to be followed for the diagnosis and prescription, the same principles will be applicable to a telemedicine consultation. RMPs may prescribe drugs via telemedicine only when they are satisfied that they possess adequate and relevant information about the patient's medical condition and that the prescribed drugs are appropriate for and in the patient's best interest. Prescribing drugs without following due process might amount to professional misconduct. There are specific restrictions on prescribing drugs during consultation via telemedicine, depending upon the type and mode of consultation. Now, they've given this table. I've modified that table for easy understanding. This lists various drugs under 4 categories. List O, List A, List B, and List of prohibited drugs. The List O constitutes OTC drugs, and there are no restrictions in telemedicine. List of prohibited drugs should not be prescribed at all in telemedicine under any circumstances. Now, List B drugs can be prescribed in follow-up consult for refill only, irrespective of the mode of consult. No add-on drugs to be prescribed and no first consult drugs to be prescribed from the List B medicines. As far as List A medicines are concerned, they can be prescribed in follow-up refill drugs in any mode, and however, in video mode, these can be prescribed also as add-on drugs or as first consult drugs. Issuing a prescription on telemedicine, the RMP shall include in all prescriptions name, qualifications, registration number, address, and contact details of the RMP, name, age, sex, identification, and contact details of the patient, name of the drug being prescribed in capital letters, along with a clear mention of the formulation, dose, frequency, and duration for which the drug is to be taken, date, time, and place of writing the prescription with signature and stamp. Provide a clear photograph, scanned or digital copy of a duly signed prescription to the patient via email or over any other messaging platform with his full name, qualifications, and a registration number clearly visible on the prescription. The e-prescription is valid for 2 weeks from the date of issue or once a pharmacist dispenses the prescribed medication, whichever is earlier. In cases where RMPs have to transmit the e-prescription directly to a pharmacy, they must ensure that the patient's explicit consent is taken for his choice of pharmacy where prescription has to be transmitted. Medical ethics, data privacy, and confidentiality. Principles of medical ethics, including professional norms for consent, standard of care, protecting patient privacy and confidentiality, handling and transfer of such personal information to of the patient as per NMC Act and data protection laws shall be binding and must be upheld and practiced. Misconduct in telemedicine. In addition to all general requirements of professional conduct, in telemedicine, violations of patient care or privacy and confidentiality are very important. Some examples are insisting on telemedicine when the patient requests an in-person consultation, using patient images and data without consent of the patient, prescribing drugs from the prohibited list, prescribing medicines without diagnosis or provisional diagnosis, soliciting patients for telemedicine through advertisements or inducement. Penalties for misconduct are as per the NMC Act, and other prevailing laws. E for telemedicine consultations. Telemedicine consultations should be treated as the same way as in-person consultations and charge an appropriate fee. He must issue a duly signed receipt for the patient for the fee so charged. So in conclusion, I would emphasize that NMC appears to be serious in implementing its new regulations. Some minor changes are expected in regulations related to generic medicines and perks of
मीटिंग खत्म हो जाए फिर आती हूँ.
the review, which is under
मीटिंग
review.
खत्म हो जाए फिर आती हूँ.
It is in our own interest to adapt ourselves to these regulations. Earlier, the better. Peaceful medical practice today is much better than roaring medical practice. Thank you for your patience.
Thank you so much, Dr. kOHLI, for such a nice, extensive, exhaustive deliberation. You have covered almost all the aspects of the new NMC guideline, which I think we all has to adopt and start practicing right from the now only. Now I'll ask Dr. Shada ma'am to comment. Ma'am,
I think after such an exhaustive lecture of Dr. kOHLI, I have to go through this 3 times, and I think, it is pretty clear to me what all is there. I think we have to see to it that things are implied.
Ma'am,
the presentation has to be again.
Ma'am, Dr. Sadhna Gupta has to leave, but she has left her comment and she has mentioned in the chat box that an MC needs review. We need countrywide preparation for implementation of many sections of it. It must be tool for empowering doctors and not restrictive. In many countries, too much restriction like Russia, there has been lack of upgrade of skill. USA, there also has been a marked reduction in availability of the doctors. As well, there are doctors, especially the obstetric care desert in the USA. The tone is like doubting the doctor's intention. It must be respectful. Let us hope we'll come out with the better version of NMC. Now, can I have the comment from Dr. Aggarwal?
Yeah, thank you, ma'am. Am I audible?
Yes.
Okay. So, first of all,
You're not audible. You're not audible.
Yes.
Am I not audible?
You're
Very
not
clear.
audible.
That's good. I'm clearly audible. Hello.
This is not clear. You have to increase the volume. Be little clear.
Is it better now?
Yeah, it's
Yes.
better.
Yes.
So, first of all, profound greetings and thanks, Dr. kOHLI, for such a comprehensive presentation. So, being a teacher, I can't help but start with asking a small question. So, as far as consent is concerned, I mean, just, poll from all the audience. So, there is this law that there is NMC regulations, which we've been hearing just now, and that Supreme Court, which is presently suspended, that pre-printed forms may be used. Okay. So, which would be superior? Can we have an opinion poll from our listeners? Which is superior now, the Supreme Court or the NMC Regulations 23? What do we think?
May I give a clarification first? Yeah?
Yes.
Yes, sir, please.
See, that preprint about the pre-printed consent forms was an observation of the court. That was not the ratio of the judgment. So that does not become the law. And that was just an observation. Although it was seriously made by the judge. Now with the NMC clarifications, the law has been made. This is the law. So pre-printed forms, there's a catch there. They have said that the pre-printed forms may be made and got approved by the SMC or EMRB. So every individual cannot go and get the approval of the consent forms from them. So I have suggested that the organization, the body, can prepare consent forms, pre-printed consent forms for the main operations, and get it approved from the SMC, and that can be used by all the members. So I think NMC has made the law, so there should be no dispute about that.
Yeah, so that was exactly the point. Thanks for clarifying. So, so anything over and above a Supreme Court law, which is enacted by the Parliament, automatically, becomes superior to whatever Supreme Court says. That is one. Secondly, a point was regarding continuous professional development. So, as the system goes, we need to do a lot about it whenever it is implemented. So normally when a CME happens, we collect the certificate and go back home. The certificate mentions, okay, for example, 6 credit hours earned. How would a CPD end? I want to know about this. How would a CPD end? What is the process?
See, after the CPD, the organizer, the institution which has organized the CPD, they have to make an internal evaluation of the participants. One, they have to take their feedback. Two, and then send their report to the EMRB. EMRB has an accreditation committee. They will evaluate, and then they will they might give some suggestions for the future maybe, and they will accredit and allot the credit points. So this is
exactly, yeah. So exactly that was the point. Thank you for the clarification, sir. So now we do not get a certificate at the end of the CPD activity itself. We will get it after a couple of weeks or months after the CPD ended, provided we have submitted a feedback form which has been circulated by the organizers. We fill it up. Normally, what they do in the West is they give you a Google link and you submit it all in a Google form. And whenever it goes up, the data is collected, analyzed, and then only the CPD points are issued to the organizers, and the organizers pass it on to the participants. So this is going to be long activity, and we have to go with a prepared mind that it is not that we have entered it and we have got the CPD points. The CPD points will be earned only after a couple of months or weeks after the CPD has ended. Now this would entail a lot of training in something called as MET, medical education training. Okay. Now it is a full-fledged dedicated activity which has been started by the erstwhile MCI and now continues for all the medical colleges in the country. Now it for basic, it has got a basic workshop. It is called a BCW, basic course workshop in MET. Then there came a revised basic course workshop. Then there came a CSIP, CSIP 2, CSIP 3, and then now they're going for diplomas also. It's a 6-month diploma. Earlier, it used to be 1 year in advanced course in medical education. But that part, we would still need a basic course workshop for all the organizers. Now, when we say organizers, we all are organizers of CPD. We will be in future. So we will all have to undergo. It is not officially mandated by the NMC, but it will become a necessity because we have to either attend or organize CPD activities for our colleagues. So it will entail a lot of, some homework into MET from those people. We have to, get trained who have already undergone these courses in MET. Of course, in Maulana Azad, for example, or there are regional centers, there are nodal centers throughout the country. MAMC is one of them. Of course, they would not take it up for private doctors. They take it up only for medical colleges faculty. So we will have to organize it at our own end. Normally, this course runs for 3 days in succession. We will have to maybe formulate a small course so that we know the basics of MET, and we can organize CPD activities, design a feedback form, and enable the collation of data so that the NMC does not raise any objections in the conduction of the entire program itself. So this will be a carry home activity once this thing comes into force, and we will have to first of all learn ourselves and then move forward. So this was from another last point is there anything positive in this, the entire regulations 2023?
Whether Dr. Aggarwal, whether it is positive or not, there is a lot of restrictions on the doctors. I can definitely see that. But अगर आप देखेंगे in comparison to 2002, बहुत ज़्यादा difference नहीं आया.
Exactly.
बहुत ज़्यादा difference नहीं आया.
Yes. So my point when raising this question was a very important aspect. Is there anything in the regulations 2023 which I can use to defend myself in front of the disciplinary committee and say that, okay, I want to bring it to the fore of everybody that there are a lot of points and almost 2 full pages in the regulations 2023 that are ready-made defenses for me. For example, can I say that I was loaded with patients, I was too busy in this work, OPD, surgery, inpatients, and running from one hospital to another one. Can I say this? Yes, I can say this. Okay, it is a law in itself. It is given in the regulations. Can I say I had a personal loss in the family, for example, and because of which I had obligations and my mind was disturbed. So maybe I could have erred, okay, or maybe I misbehaved with the patient, depending upon the patient's complaint. Can I say that? Yes, I can say that. Can I say I was under depression? For just an example, I was under so-and-so mental issues. Okay, maybe I may have to support it with a prescription, maybe not. But then I can use these defenses. There are other couple of defenses that I can use in my defense, which are, very nicely there in the regulations 2023 itself. So this is, I would say, a very, very positive aspect, and this is entirely new. And, the doctor, it's not that, okay, I'm ready to be crucified on every small misconduct, every small, act becomes a misconduct. There are a lot of things that I can use to defend myself nicely in front of the NMC. So this was all from my end.
I can say the consent has been also reorganized. I like the consent part it also very well. Any more comments, Dr. Leena, Dr. Raj, Dr. Ila?
Sangeeta, please.
Yes,
From you, ma'am.
I just want to say that I am rather feeling very happy to listen to NMC guidelines, though we do not know that what small steps are there on which we are going to crash down. But actually, most of the things are very appropriate, what I think. And I think it is going to organize our things. But the only thing is how it will be done, like taking credit points from them and all those things, because it has been advised prior also to take credit points and all, and still we could not get it from anybody, like in spite of making booklets, passbooks or something like that, it was not possible somehow. Maybe so
Dr.
many.
Ila, when it comes into force, it is going to be very smooth. I've seen a similar concept running, maybe I could quote the state of Pennsylvania in the US. So this is what happens. They give a Google form, you fill it up, you submit it, and on mail itself, after a few couple of months, you get the CPD, certificate, the credit R certificate. So of course, there could be hesitancy, in the beginning, but later on the system should become smooth enough. I hope so.
And another thing I want to say that NMC, we were registered in MCI, and NMC has got our registration under NMC now. It is transferred to NMC. So we are, our name is there in NMC already as from the NCI. So again, if we have to work in some other state, then we have to take registration in that state medical council. As I have taken from UP because I am residing in UP, I have already MCI and I have a state medical council like DMC certificate also. So even then I have to register again for the UP MCI, and additional qualification had to be also registered in state medical college, because if you don't have additional degree in that, then as it is stated in the NMC guidelines that you cannot display that you are MD if it is not added in your qualification. So there are few things which are very good to learn, and then we have to be really savvy with the computer so that we can do all those things online, on and on and on. That's what I want to say.
Yeah, that is correct.
Yes.
But in addition to that, we also have to register separately and directly with the NMC itself, although that will be an online process and the details have not come up as yet. But maybe, it will be a once in 10-year activity, renewable. We don't know.
They give this particular activity. People like me have got a certificate from them that, I'm a registered doctor with this thing. So I'm sure all of you must have also got the same.
No, madam, I applied it, but I still didn't get any reply. Any
वो तो instantaneously आ जाता है डॉक्टर साहब उसी दिन
नहीं आया मैम, नहीं आया.
I could not even find the link from at NMC website.
I could find the link, and the link was through my Rajasthan State Council. So
वो तो State Medical Council का हो गया. I am talking about the NMC website.
My form, all the details, the NMC form.
Doctor, this came in month of May. This came in the month of May, and I got my registration done in the month of May. It was free of charge.
At NMC website. Okay.
Dr. kOHLI, my question is that when we go through the guidelines number 5, as far as the consent is concerned, they have given they have advised for a surrogate consent in a case when the patient is indisposed. So by meaning of word indisposed, do you mean that patient who is under anesthesia also, or the patient's consent has to, what is the meaning of indisposed? They have typically used the word indisposed. That in the case where patient is indisposed, the patient's relative or any surrogate can give the consent. Can we take this as a consent for surgery when patient is under anesthesia? This indisposed one.
Yeah,
Ma'am,
I
can
think
I
so.
say something?
See,
Yeah, Dr. Gaurav, please.
No, Dr. kOHLI. The question is for Dr. kOHLI.
Yeah.
See, number one, there are ambiguities in the regulations.
Yeah.
And
That's what.
we can twist the ambiguities in our favor wherever we want. Till a clarification comes from NMC.
Clarification, if someone asks, then only there will be clarification, because the Supreme Court doesn't give any authority to any other person in all the previous judgments that consent can be given by any other, same as in Samira kOHLI case. So I was going in detail, and then I focused on the point. You have written it in the blue in your consent, and in your red lines you have made your own interpretation that it can be for the surgery. But I don't think so that while going through the NMC guidelines number 5, that implies for a patient who is undergoing anesthesia. So this is a very important clarification, that whenever we find anything, yes, Dr. Gaurav.
Let me respond first.
Yeah.
You see, they've used the word surrogate.
They have used the word indisposed also.
Yeah, fair enough.
Yeah.
Secondly, in the Samira kOHLI judgment, this issue was not taken up. The proxy consent, surrogate consent. This was not taken.
Issue was not taken up, but when it was a case in the court, then that mother, 78 years old mother was not taken into consideration, and it was found to be not invalid.
Yes,
It was
see,
found to be an
the-
invalid consent. Proxy
because the patient herself had not authorized that mother
Yes.
to give consent on her behalf.
So that's what I want
So-
to ask, that this present NMC 2023 guideline, did it authorize any person to make a surrogate person before undergoing the surgery?
See, power of attorney is well known. You can authorize another person to take decisions on your behalf.
No, but that power of attorney in other cases is different, but in a case where the question of life and death is concerned and we say that patient, so the power of attorney word I have not read into any of judgment, only one the discussion it was once there that the that power of attorney automatically transfers to the surgeon, not to the relative. When patient is under anesthesia, the power of
This particular issue in this form has not been legally tested in any court, firstly. So, but common sense says that if I have to undergo surgery and I authorize my wife to give this, take a decision on my behalf, if something happens, and I give it in writing.
So we have
So
to
that is
change
okay.
our consent form, or we have to add a line in all the consent forms that
Please separate
See-
attorney.
No, not necessarily separate. See,
it
when
is
I
in the
was in
same consent form, we can add a line then.
See,
It can
in
be
two-
add-on.
Yes,
Yeah, I
yes,
authorize
yes.
such
in
person.
2-3 hospitals, we have already used this proxy consent as a part of the admission consent. In the admission consent, towards the end, we had been using this in Artemis Hospital and another hospital. You make a statement that I authorize the following person, maybe 1 or 2 or 3, and give their name, the relationship, and their telephone numbers. And that served us very well. This has not been tested. This aspect has not been tested legally in any court.
Yeah. No, not has
Dr.
been tested,
Neelu,
but
Dr.
yes.
Neelu, yes.
I think Dr. Neelu has left.
No,
Can
no,
I
she
come
wants
in?
she just said she
yes,
wants to
Dr.
ask.
Gaurav,
Okay,
I want a clarification.
Can I attempt to answer?
There's
Yes,
some
yes, yes.
network problem.
So
now-
it goes without saying that a patient in anesthesia can give consent. It is invalid, number one. Number two, if there is an emergency, there is no need of consent. Doctor can, take the prerogative and go ahead with the procedure that whatever is required.
Life threatening.
Yes,
Only-
yes.
only
If it is only if it is life threatening.
Not
Yes.
even all the emergencies. It has to be life threatening.
Yes, life threatening only. Yes, yes.
Ah.
When I say emergency, it would mean yes, life threatening.
Life threatening.
Anything
Emergencies
that
is
causes
cesarean also.
danger to the life. Yes,
Yeah.
yes,
Yeah. So it has to be life threatening. Yes. Next.
yes, yeah.
So that implies anywhere. I only want to clarification under anesthesia. Life threatening.
No, it is in consent under anesthesia is invalid. It is illegal. It has no value at all. The patient is not composed. He's not conscious at all.
So we all have to join together and follow the principle of taking the consent on admission or before the surgery. I think if we
pre-surgery,
all
yes.
start doing
Yes.
this,
Yes.
then we will be out of the soup.
Yes,
Yeah.
absolutely.
I give
Dr.
props-
Leena, comments?
Ma'am, what I can understand is, and this is a very important point which has been raised, is that now proxy consent we could put in, like supposing we are planning a surgery where, it is like, okay, I'll open up and, I may be operating on your endometriosis, but it looks like you have a tumor mass, I may have to sacrifice your ovary. Things like that where, where there is a little discrepancy, we could possibly take a proxy consent beforehand.
No, Dr. Leena, this is not a proxy consent. This is not a proxy consent. Proxy consent is a given by the proxy person. It is a detailed consent showing that yes, we have informed you the complications and this might happen. And this is not proxy.
So then when do we take that consent? So supposing we are operating and we
Before
find there is
surgery,
something.
before surgery, that person authorized.
So I'm authorizing this person to give consent on my behalf when I'm under surgery.
Yes.
So does this mean that once the NMC guidelines are very well in place and active, we would be taking this kind of consent in all our consent forms?
Yes, that implies that. But NMC has also not clear. NMC has used the word indisposed. I don't mean
Indisposed,
that
yes.
the patient was not indisposed before surgery, before undergoing anesthesia. Patient was okay, alert. The patient was not indisposed.
See,
So it
the
is a very
So there is,
ambiguous,
I think this is a very ambiguous situation,
sort of thing.
which
Yeah.
needs a lot more clarification before we jump into, using this particular thing. The other thing is, one very nice point which Dr. Kohli mentioned about the prudent doctor principle, which we were all following, all of us, the UK guidelines. We are all slowly, going towards the prudent patient principle of the American way, of discussing all the risks. I think this is happening because of the kind of problems that we are seeing all around us, and I think the guidelines are also telling us the same things, the disclosure of risk. So that was something I really liked, because that was just putting it into perspective of what we all have now started doing in the medical practice.
So let me just make it clear here. The booklet is, you find that many doctors, if you go say, I went for a total knee replacement, so they give you a booklet. कि डॉक्टर उसके बारे में सारा पढ़ लो. But what I feel, what is recommended is, आपने सब बता दिया, consent ले ली, उसके बाद हमारे जैसे लोग ना, what we have started doing it, फॉक्सी की एक कॉमन कंसेंट है 3-4 पेज की, उसको हम व्हाट्सएप में देते हैं, उसको कहते हैं आराम से पढ़ लीजिए, उसको फाइल में भी लगाते हैं, and before the surgery is happening, we take detailed consent again on this particular Foxy form. Other consent they have already given specific procedure specific, but this detailed consent, we give them a form earlier. We, on the day of the surgery, we take the consent again here.
Madam, that is the informed consent of the Foxy.
Yes, agree.
Yes.
Proxy की तो बात है, proxy का तो ये मतलब है मेरा ऑपरेशन हो गया, होने जा रहा है, even if I have not, वो कहते हैं अगर स्पाइनल भी है तो भी वो पेशेंट को कंसेंट नहीं दे सकते आप उसको, उसमें आपको बोलना पड़ेगा भी मेरे हस्बैंड देंगे या मेरा सन देगा या कोई देगा, उसको बोलते हैं प्रॉक्सी कंसेंट.
See, imagine in the Samira Kohli case, if the patient had given a written proxy consent in favor of her mother, that during anesthesia, if some decision has to be taken, I authorized my mother to take the decision, the complexion of the judgment would have changed.
Yes, that's what my answer is, that if we all start taking these sort of consents, even in all elective cases, I think most of our problems will be taken care of.
Dr. Alka Gupta wants to say something. Dr. Alka Gupta?
You're muted.
Please unmute.
Unmute kariye.
Good evening, ma'am. I want to know, there was previously it was not necessary to give a consent by husband for the sterilization of the patient. But today, and the today's doctor has told that there is compulsory husband consent is required.
May I answer? Doctor, Government of India guidelines, health and family welfare says that the consent of only the patient or the lady. But NMC guidelines says that wherever any reproductive things are under consideration, consent of both should be taken. So I think, to be on the safe side, we should ask the husband also to give the consent, and even at the time husband is not present, I think the next day we can take the signature of the husband. That's the best thing which we can do.
And that is not for MTP also? Is this also?
Not MTP, not MTP. Dr. Sanjeevani.
Okay.
So, can I come in for a moment?
Yes.
Yes.
Let
So
Dr.
Dr.
Sanjeevani, let Dr. Sanjeevani speak, and then you come.
Thank you, ma'am. Thank you, ma'am. And I think it's been a wonderful session with so many aspects covered by Dr. Kohli. In addition to what he mentioned, he would be discussing 5. I am fully in concurrence with Dr. Sangeeta Gupta's issue raised by her. And I think that needs clarification. So that's one thing, because we are not to do anything more than what the consent has been taken in advance, except in life-threatening situations where it shifts on the doctor to save the patient somehow, whatever procedure you have to undertake. For that also, you should have a witness or 2 witnesses that it was justified. Now, one different point is that one different aspect of this is that when we are providing a certificate of illness, the patient having suffered some illness or admission, from this state to this state, the patient should be present there and should sign or thumb impression as well as the doctor sign. And we should remember sometimes the husband or somebody else will come for a fitness certificate that now my patient is well, give fitness, she will join duty from tomorrow. No certificate should be, such certificate should be issued in the absence of the patient. If she is fit, she has to come. If she is unwell, she should report to hospital anyway.
Absolutely correct. Absolutely correct.
Never give anything in absence. So, ma'am, this is for now. Of course, this has intricate. I think if we read those pages in English from 70 page onward to 124, it is truly, like you said, like a Gita for us. We have to have a legal bent of mind, which Dr. KOHLI has stimulated very nicely and put us on the right path. We can't say that knowing about medical commission is optional now, that is what we like. We have to follow what is not of guidelines said in Dr. Gaurav said it is going to enhance our practice and make us feel
very clear. Only the people had 2002 guidelines, and that's why we said 2002-3 guidelines should be taken as Gita, and every doctor must read it. Not only read it, reread it.
Very true, ma'am. Very true.
Now they should read this 2023 guideline. I think it is a little extension to that 2002. So if they should go
2023 yes.
guideline. This
This
is
is modified, but I think these guidelines are going to come back to you as it is, except something with the drug controller, prescription you have written in telemedicine, and whether the person lady is going to take a prescription for one chemist shop, the second chemist shop. There is no categorization as far as we are concerned. It's happening outside, so one of those sentences has been written. But I think Dr. KOHLI has very clearly said what is patented, what is not patented, and non-patent also coming from the medical multinational companies. Whole lot of things. I think we need to change ourselves.
And one more thing, ma'am.
डॉक्टर साहब बाय नेम नहीं लिखा था, सब जगह जेनरिक नेम से ही जाता है. डॉक्टर साहब मानना पड़ेगा. हम लोग कितना पीछे हो जाएंगे. बिल्कुल, तो फिर तो अब गांव में रह के प्रैक्टिस करें ना. कुछ भी तो चीज नहीं चाहिए हमें.
Should we wrap up now? And can I ask Dr. Shakuntala to say the word of thanks?
Just last comment, ma'am. So Dr. Sangeeta, Dr. Khanna, that question has already been answered in the Samira KOHLI judgment itself. So to my mind, there is no ambiguity. As far as predisposed, the Samira KOHLI judgment clearly says that in 3 situations: minor, mentally challenged, and incapacitated patient. Now this NMC regulations has picked it up as it is, but instead of the word incapacitated, the regulations have used the word predisposed. But it's the same thing.
Indisposed.
So indisposed, yeah. So indisposed. So it is the same thing in these 3 situations. When the patient is indisposed or incapacitated, next of kin can give the consent. It is very clear. So there is no ambiguity. Let us say the patient is very sick. I would not talk of pre-surgery. Even if the patient is under the effect of, let's say, pre-surgery, pre-surgical medication like maybe midazolam or plain and simple diazepam or whatever, that is also the invalid consent. But if the patient is incapacitated because of severe weakness or something that the patient cannot sign or cannot understand, then next of kin, this immunity is provided by Samira KOHLI judgment, can give the consent.
Sir,
So to my mind, there is no ambiguity. Yes.
Samira KOHLI's case, patient was taken for a diagnostic laparoscopy, and you did a hysterectomy, taking a consent to natural. That lady was annoyed.
Absolutely, absolutely.
Ma'am, can I ask one question? Now this is regarding the FOXI consent form, because they are not only now, till now they are not approved by the NMC. So can we use them? As per Dr. KOHLI, what you have mentioned, this
Yes, till such guidelines come into force, you can use them.
What we already, yeah.
No, but they have not been, they didn't get the approved by the NMC yet.
But the NMC regulations are not in force. When they come in force, we get them approved
But you
at
have
that
to
point
get
of time. Yes.
Correct.
Yes.
Kuntla, wind up.
Yes, ma'am.
A doctor, what we are called registered medical practitioners, we should hold our fort, and we should, like, be strong. But to be strong, you have to be knowledgeable, have read everything. You can't just become strong like that. So most of the time, we are not making a mistake. We are doing ethical, honest practice. We are counseling the patients well, explaining all the possibilities, and of course shifting from the UK system to the American system, more or less, so that the patient is well informed, giving incidences of complications which can occur during a surgery or during any treatment plan, not very remote complications, but the complications or the side effects of a medicine or something. So we are counseling them. We don't have time to record everything, but the doctor should know how to put it in words, what counseling has been provided in 2 or 3 sentences. It is important to follow documentation guidelines as for OPD or inpatient to be strong. A good document is very protective always for us.
Doctor, I can tell you about my daughter's case.
Ji, ma'am.
You can't be gifted even a pen. Secondly, if you are going for a professional talk, listening, you can't take your husband who is a non-medico there. He can't have a dinner there. Secondly, I think their rules are so stringent. You have to follow the rules. आपने पेशेंट देखा है तो आपको स्टेट को देना पड़ेगा एक कागज कि आपको ये सब चीज करके दिया है. डॉक्टर साहब, दे आर वेरी वेरी क्लियर. हम तो कुछ भी नहीं है उनके सामने. डॉक्टर साहब, हमारे पर तो कोई डंडा ही नहीं है.
Very true.
We have to discipline ourselves, even if we don't have a danda. We have to learn what is happening globally and what we should do to be providing the best possible services to the patient. And then we don't have to be scared.
Yes.
Dr. Convener has
about
given a very neutral judgment, a neutral representation of the NMC. And we will hope for what the new document, gazette notification which comes, so that again we are stable. Yes, ma'am.
Somebody commented about, the State Medical Council or the NMC, what kind of punishment they can give. They can only put you off the register. It means if they put you off the register for 3 months, whatever the monetary loss is indirect. So this is what it is. They cannot take the monetary compensation. Monetary compensation only comes from the CPA courts.
And ma'am, after the whatever you have suffered some punishment from them, like a temporary suspension of the license for 30 days or 3 months or even longer, after that it is understood that you can get back into practice. You do not have to take a fresh certification that you're good to go.
Absolutely, you're right.
Yeah.
Right. So can I wind up with the permission?
Yes, ma'am.
It was a wonderful deliberation by Dr. kOHLI, and with the experts' pearls of wisdom. The ambiguity in the NMC guidelines will be to our benefit till further clarified. We can only display our degrees and diplomas that are recognized by NMC. The cross-pathy is very much prohibited, and even if you refuse our patients to treat, we cannot abandon our patient. The fee splitting is prohibited. The digital platform has to be used only for telemedicine with strict protocols. There are no gratifications that are to be received from pharma companies. The advertisements are completely banned. The prescription of generic medicine is not mandatory, but it is very much recommended. We have to ensure that in the digitized platform, if we are able to keep our records, that is highly recommended. And we should switch over to the electronic medical records. The details of consent were very beautifully highlighted. The generic medicines are made after expiry of the patent medicines, and it is recommended rather than mandatory to use the generic medicines. And the various brands were highlighted as to in category 2 and category 1. The self-directed learning is highly recommended, and the telemedicine guidelines are very much in place, and it is a piece of medico-legal document. That is why the law of the land must be followed. So I thank all the experts the chairpersons and Dr. kOHLI for this beautiful deliberation. It was very exhaustive and to our benefit. Thank you very much.
Ma'am, please share the slides.
Thanks, Dr. kOHLI, for
Thank
such
you.
a wonderful talk.
Thank you. Thank you.
It was really,
Thank
really
you very
good.
much.
Thank you, Dr. kOHLI.
Thank you. Thank
So
you.
much
Thank you,
time
Dr.
and
kOHLI.
Dr.
I
kOHLI,
focus
enjoyed
on
the
this
discussion.
topic for all of us.
I enjoyed the discussion.
it was
You were
really,
really very good.
it was really good. Thanks to everyone.